It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show.
Yeah, lot of controversy that do not disturb me. Got dreams of a million, cannot defer me. Got a ring on my finger, I retired my jersey. Fuck, nigga, y'all suck like the plot of Kirby. I'm him. All black on the scene, doing me high. No, I got the game covered like knee highs. I be killing on my foes like FIFA. Flows on kit like FIFA. Fila, E-I-O. Green on me like G.I. Joe. Hold my chest like a peacock glow. Southside nigga with an eastside hoe. Hitting at the chicken number 3 combo. Type of nigga lead EB John Doe. 3D Camp Creek on the creek zone 4. With a nigga play street. Living cheeks on the floor. Can't speak no more. First verse in surgery, it's only me versus me. Nobody else hurting me. I burn niggas to the 3rd degree. Like Jazz O, nigga certainly. The best nigga that rap, I don't mean just virtually. These are the 4 Joe worker bees. I flex up like Hercules. I hit a nigga in the shit so hard that it hurt to sneeze. It's Nolan.
What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody is doing well out there. Y'all give me a second. I got to put my branding back in the motherfucking shot. Hold on. Give me a second. Yeah, we wasn't finna be sitting here all day without that on there. But salute to everybody tuned in. Hope y'all doing well. Before I get into the specifics of this whole Megan Thee Stallion, Rock Nation, Emilio Garcia situation, we have received an update on new single coming from Megan Thee Stallion, which will be out on Friday, called Lover Girl. All right? So that song that she's been previewing on TikTok for the last few weeks, it is going to be out on Friday. The song is produced by Jacob Dior, who is a new producer. He started producing 2 months ago, and within his first 2 months of releasing his music and his beats online, he has a record with Megan Thee Stallion. Salute to that. Ain't that some shit? All right. Now, let's get to the nitty gritty of what is going on currently with Megan Thee Stallion, Rock Nation, and Emilio Garcia, aka Emilio Coochie. If you don't remember what's going on with this case, Megan is being sued by her former cameraman / photographer, Emilio Garcia, aka Emilio Coochie. All right. He is suing for alleged workplace issues. He feels like she violated labor code in firing him without much of a notice. He is also suing her for an alleged incident that took place in Ibiza, basically sexual harassment, in which he claims that he was forced to witness sexual activity between Megan Thee Stallion and a couple of her female friends. We don't know if that ever occurred or if that's true. Just saying that's part of his lawsuit. And he's also suing Rock Nation for unpaid wages and things of that nature, right? So this has been going on for a year, and we haven't really made too much headway with this. Now we have a bunch of filings in the docket that are coming in. This has been sitting dormant for about 2 months, and now we just have a flood of paperwork that's been uploaded. So I want to try to run through some of it so people can be updated on the status of the case as it stands. All right. This is going to be a kind of long video, so make sure if you need to get you some refreshments, food, snacks, get them on the way. Put this on the loudspeaker while you cook. Do what you got to do. All right. Let's get to it. All right, so this piece here was filed 2 days ago, and this is a notice of Pete defendant's motion to exclude the expert opinion and testimony of Dr. Jessica Rowe. All right, and Pete defendants includes Megan and Rock Nation and, of course, her companies. So there's a so-called expert witness, this Dr. Jessica Rowe, who wrote a report based on the facts that have been presented in this case, largely based on the complaint of Emilio Garcia. And she also took a deposition, right? But she wrote this report that's highly favorable to Emilio Garcia. Now, one of the issues with her report is that she did not engage with any of the information presented by Megan Thee Stallion. So she went through Emilio's deposition. She went through Emilio's, his complaint, his workplace issues, his personal issues with Megan, so-called harassment that he went through. but her report was published before she ever actually had the opportunity to engage with Megan Thee Stallion's deposition to hear her side of the story. So she wrote this report without anything involving Megan. It was all just information presented from Emilio. All right. So they say here, please take notice that upon the accompanying memorandum of law, the declaration of Joanna E. Manillo and exhibits here too, and all prior pleadings and proceedings herein, defendants Hot Girl Touring, LLC, Megan Thee Stallion, etc. Megan hereby move this court before the Honorable Gregory H. Woods at the Daniel blah, 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 for an order pursuant to Federal Rule of Evidence 702, granting the Pete defendant's motion to exclude the expert opinion and testimony of Dr. Jessica Rowe, and granting such other and further relief as the court deems just and proper under the circumstances. All right. So they want to basically strike her expert testimony and expert report from the record because it does not properly reflect all of the information at hand. Here we get further into it. So defendants Megan Thee Stallion Entertainment, etc., etc. Here is under the law why they believe that her record should be struck. All right. Preliminary statement. Rather than remain faithful to an expert's role of providing unbiased and objective opinions to the aid and trier of fact, Dr. Rowe came to conclusions unmoored to any reliable principles and methods and routinely took up the mantle of the fact finder herself. Specifically, an entire section of Dr. Rowe's report adopts wholesale swaths of Mr. Garcia's First Amendment complaint, the FAC crediting them as accurate without any independent analysis that would justify doing so. She made credibility determinations about Mr. Garcia, confirming her opinion that he was not BSing anyone. She made psychological diagnosis of defendant Megan Pete without ever having met her, let alone examined her, and opined on her motivations and mental state. I want to just reiterate this piece here. So she accepted large areas of Mr. Garcia's complaint, crediting them as accurate. But then she turned around and made psychological diagnosis of Megan Thee Stallion without ever meeting her, examining her, you know what I'm saying, or knowing really anything about her. And she impermissibly opined on legal conclusions, including that the record, based on Mr. Garcia's allegations alone, demonstrated the existence of a hostile work environment. That is inappropriate. Dr. Rowe's report and deposition testimony reveal her intent to exceed her expert authority and offer opinions at trial based on her personal judgment of the law and the facts, not the product of reliable scientific principles and methods. But that's what you bring a doctor in for. But that is the sole province of the trier of fact. And that is precisely why her expert opinions were previously excluded by another court, they say. This court should do the same and exclude Dr. Rowe's report and testimony based on it that exceeds these bounds. So they're now saying that she has a history of doing this and also has a history of her opinions being taken out of court. Background. Dr. Rowe is a clinical psychologist who holds herself out as an expert in mental disorders and psychological assessments and purports to assist attorneys with conceptualization of cases. Though she acknowledged her obligation to be neutral and objective in analyzing testing data and information and make forensic psychology assessments, her report and testimony in this matter is anything but. Dr. Rowe's conclusion to a reasonable degree of probability that Mr. Garcia experienced mental harm from the defendant's actions were based on Mr. Garcia's allegations in the First Amendment complaint, which she copied and pasted directly into her report. So she took large portions of his lawsuit, copied and pasted them into her report instead of drafting it herself. She described this copy and paste approach as her common practice. And rather than recognizing that these were unproven allegations by a litigant that stands to gain financially, she testified that her only source of making sure the facts stated in this case are accurate was Mr. Garcia without collateral sources. She talked with Mr. Garcia about each of defendant's actions and went through, explaining that she did not examine anyone other than Mr. Garcia and did not consider any depositions transcripts other than Mr. Garcia's in preparing her report. Dr. Rowe's testimony further revealed her intent to serve as a human lie detector in front of the jury. At deposition, she testified that during her meetings with Mr. Garcia, she was deciphering whether or not this guy was full of crap, quote unquote, and looked for specific nonverbals or verbals that people do when they're lying and trying to deceive. She opined that Mr. Garcia was a credible witness and that he was not BSing anyone. A basis for this conclusion was her prior experiences of working in a prison, proclaiming, "Trust me, I've met and seen those people before." This is the so-called doctor that was brought in as an expert. Dr. Rowe also opined on the state of mind of individuals described in the FAC, namely Ms. Pete, based solely on Mr. Garcia's allegations. For example, she concluded that certain alleged behavior was consistent with Pete's anger. She adopted Mr. Garcia's claim that Ms. Pete directed her rage at him, ascribed motivation to Ms. Pete for using certain lyrics regarding two red bone kissing in the back of the seat, in the back seat, in her song Best Friend, cited on page 1 of the FAC, and speculated that purported witnesses to Ms. Pete's alleged conduct were afraid. So she is actually taking up all of the allegations that Emilio put in his claim, and she's co-signing them without having any actual knowledge of what took place or not. Even including in her own report the allegations that Megan was rapping on the Best Friend song, what those lyrics were based on real life events without her having any real knowledge of what did or didn't happen. Right? Dr. Rowe's report was also replete with diagnoses regarding Miss Pete. For example, she opined that Miss Pete exhibited the model of dark personalities, commonly referred to as the dark tetrad: narcissism, antisocial tendencies, Machiavellian exploitation of others, and sadism, though she had never examined, met, or even spoken with Miss Pete. Now that's crazy. She further concluded that the evidence reviewed in this case led her to infer that the following characteristics by Miss Pete and the Pete defendants were present: unchecked victim blaming, a phenomenon called the scapegoat mechanism, a maladaptive response to allegations where complaints are discounted and misconduct is minimized or rationalized, institutional betrayal, and destructive leadership. So this is very interesting to me, right? And this is why discernment is so important in this world, because people can come to you and say, "Hey, I work in this field. I have knowledge of this." Even in certain situations like what we're dealing with here with the litigation going on between Megan Thee Stallion and Emilio, or Megan Thee Stallion and Milagro, or all of these different court cases that we've ventured into on this channel and across YouTube collectively, culturally. Sometimes we get people that say that they're experts or they work in these fields, and based on my professional expertise, this is what I'm deciphering, right? But you can't take everybody's professional opinion about these things, because you don't know how good they are at their actual job. You don't know how much education, they may have passed and gotten a certification or have gotten their degree or whatever, but that does not mean that they're good at their job or that they're going to be doing that forever because they're good at it. Just wanted to throw that out there. And after reading Miss Pete's deposition testimony, Dr. Rowe, hold on. Did I rationalize? Institutional betrayal, yeah. And after reading Miss Pete's deposition testimony, Dr. Rowe went so far as to opine that Miss Pete showed symptoms of Alzheimer's as a very young woman. When asked whether she believed making such a diagnosis on the basis of a deposition transcript was appropriate, Dr. Rowe deflected, claiming, I was kidding around. But for someone to be so young and for the incidents to have happened recent, that's all I'm saying. So she said that she believes Megan Thee Stallion was showing symptoms of Alzheimer's in her report. And when she was asked about that diagnosis in the deposition, she then claimed that she was joking in her official report to be submitted to the courts. Now she's saying I was kidding around and that people were supposed to be able to decipher that she was joking in a medical report. Finally, Dr. Rowe made impermissible legal conclusions in her report. Specifically, she opined that individuals associated with the Pete defendants, including Miss Pete, exhibited a number of physical and psychological behaviors that created a hostile or toxic work environment. She concluded that the Pete defendants created a hostile work environment replete with discrimination, retaliation, and disparate treatment, such that Mr. Garcia merits punitive damages. And she opined that plaintiff was misclassified as an independent contractor while working as a personal cameraman to defendant Pete. Dr. Rowe's opinions as to legal conclusions have been excluded by other courts. Just 2 years ago, Dr. Rowe was precluded from testifying as to her legal conclusions and opinions and as to jury instructions regarding the occurrence of harassment, retaliation, or cruel treatment in another alleged workplace harassment case. Damn. This is a quote. The court further admonishes the expert not to testify as to any case-specific facts from the medical records and not to use any language included in her report about the conduct of the school district amounting to harassment, retaliation, or cruel treatment. The expert cannot testify as to legal conclusions and opinions or about jury instructions. So that is a quote from a previous case that she was trying to be a part of, and they completely said, nope, do not use any language that she's presented. Legal standard. Federal Rule of Evidence 702 permits an expert witness to testify if 1, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact at issue. 2, the testimony is based on sufficient facts or data. 3, the testimony is the product of reliable principles and methods. And 4, the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. The district court must make certain that an expert, whether basing testimony upon professional studies or personal experience, employs in the courtroom the same level of intellectual rigor that characterizes the practice of an expert in the relevant field. In order to do so, the district court must focus on the principles and methodology employed by the expert without regard to the conclusions the expert has reached or the district court's belief as to the correctness of those conclusions. This means that when an expert opinion is based on data and methodology or studies that are simply inadequate to support the conclusions reached, Daubert and Rule 702 mandate the exclusion of that unreliable opinion testimony. Indeed, any step that renders an expert's analysis unreliable under the Daubert factors renders the expert testimony inadmissible, which is what they're asking for, that it not be admitted in the courts. Argument. Dr. Rowe's opinions concerning the accuracy of Mr. Garcia's allegations and his credibility should be excluded. Dr. Rowe's opinions as to the veracity of Mr. Garcia's allegations and Mr. Garcia's credibility should be excluded. Her opinions concerning the accuracy of Mr. Garcia's allegations are not the product of reliable principles and methods. Rather, her opinion is based on the mere regurgitation of the paragraphs in Mr. Garcia's FAC. And Dr. Rowe's opinion as to Mr. Garcia's credibility exceeds her authority as an expert witness. A. Dr. Rowe's attempt to serve as a conduit for Mr. Garcia's narrative should be precluded. It is clear from the copy and paste approach Dr. Rowe took in her report, where she merely recited the same allegations Mr. Garcia put in his complaint verbatim, that the purpose of her expert testimony is to serve merely as a conduit to feed a plaintiff's factual narrative to the jury. That is impermissible and warrants exclusion. An expert's role is to assist the trier of fact by providing information and explanations, not to be an advocate. When expert witnesses become partisans, objectivity is sacrificed to the need to win. Granting motion to exclude expert testimony where witness seeks to supplant the role of counsel in making arguments at trial and the role of the jury in interpreting the evidence. Finding expert opinions based on insufficient facts or data or on unsupported suppositions are not acceptable, and noting expert testimony should be excluded if it is speculative or conjectural. Parties cannot present an expert to the trier of facts solely for the purpose of constructing a factual narrative based on record evidence. Where an expert does so, her testimony warrants exclusion. So here we have a quote from 2004 in a case. Expert testimony on regulatory history of a diabetes drug was merely narrative, and the expert's simple inferences drawn from uncomplicated facts served only to buttress the plaintiff's theory of the case. Another case, repetition of plaintiff's belief as to the cause of his condition simply does not reflect a methodology relying upon expert specialized knowledge or experience and thus cannot be considered reliable. Testimony permissible so long as it does not put expert in the position of merely reciting the defendant's statements to the jury in the guise of a medical opinion. That is exactly what Dr. Rowe attempts to do here. Dr. Rowe's report characterizes Mr. Garcia's dramatized description of his time working with Miss Pete as confirmed actions by Miss Pete, rather than what they truly are, plaintiff's embellished, unproven allegations. But at deposition, Dr. Rowe admitted that this description was lifted verbatim from the FAC. For instance, on page 4 of her report, Dr. Rowe states that Pete would launch into a temper tantrum, ridiculing anyone who brought food into her vicinity. This is a word-for-word replication of paragraph 27 of the FAC. On page 5 of her report, she copies and pastes the following language of paragraph 47 of the FAC. In response, Pete immediately shot plaintiff a sinister look, a look so malignant that he had never seen Pete express before. And on page 8, she inserts language from paragraph 81. Suddenly, the color drained from Pete's face and she immediately changed her tone, threatening plaintiff. Similarly, Dr. Rowe adopts attorney storytelling and descriptions of the mental state and motivations of other people from Mr. Garcia's FAC as her own conclusions. For example, on page 7 of her report, she contends that alleged behavior by Miss Pete was consistent with Pete's anger towards those who are in her presence while she was dieting, but this time Pete directed her rage at plaintiff and Alex. In adopting Mr. Garcia's narrative without any support whatsoever, Dr. Rowe asserts that Miss Pete felt anger or rage during some of the events described. Likewise, page 8 of Dr. Rowe's report states that following an incident alleged in the complaint, everyone was silent as they were all afraid to truthfully say that Pete threw the remote. And on page 7 of her report, Dr. Rowe comes to the following conclusion. The first verse of Best Friend clearly memorializes the sexual harassment to which plaintiff was subjected in the SUV. Compare with Rowe Report 7 with FAC 66. Not only is this sentence lifted directly from the FAC, but it impermissibly credits Mr. Garcia's claim that sexual harassment occurred, a determination for the trier of fact, and opines on Miss Pete's state of mind. Dr. Rowe's report is a wholesale adoption of his allegations as proven fact. This approach is unmoored to any data-driven analysis, scientific or otherwise, and it is entirely inappropriate in an expert report. Dr. Rowe was not present for these events or any of the others alleged in the complaint, and she did no independent analysis to verify their accuracy. At the time she wrote her report, she had only reviewed one deposition transcript, Mr. Garcia's. She had only spoken to one individual with knowledge of the events described in the complaint, Mr. Garcia, and she undertook no investigation to assess the veracity of the allegations in the complaint. All she did by her own account was go over the allegations presented in the complaint and confirm with Mr. Garcia, a litigant in a civil suit that stands to potentially gain monetarily, that the allegations were purportedly accurate. So they're saying she did no form of due diligence. She just had conversations with him, looked at his lawsuit, regurgitated what was stated in his lawsuit, and called it an expert report. In short, Dr. Rowe has no basis to opine on what anyone involved in the alleged events felt, thought, or saw, or whether Mr. Garcia's description of events should be credited, let alone whether they occurred. Her overly dramatized, one-sided description of the purported alleged actions of the defendant should be disregarded, and her testimony that Mr. Garcia's version of events was accurate should be precluded. Dr. Rowe's credibility determinations should be excluded. Throughout her deposition, Dr. Rowe made several impermissible statements regarding the credibility and reliability of Mr. Garcia's allegations and testimony, but that is not what experts are permitted to do. Her testimony in that regard should be excluded. Dr. Rowe routinely invaded the province of the jury by opining on Mr. Garcia's credibility. For instance, she testified that while she was undertaking her examination, she was deciphering whether or not Mr. Garcia is full of crap by looking for nonverbals or verbals that people do when they're lying or trying to deceive. She also testified that during her examination, she routinely assessed whether Mr. Garcia was BSing and trying to BS all of us. Ultimately, she concluded that she did not see that observationally from him nor in the rest of the data. Worse yet, in an effort to bolster her own conclusions, she portrayed herself as a human lie detector test, insisting, "Trust me, I've met and seen those people before. I have even worked in a prison." But whether Mr. Garcia should be believed in this case is a decision for the jury, not an expert psychologist hired by plaintiff's counsel, and her testimony concerning Mr. Garcia's credibility should be excluded. Dr. Rowe's improper testimony about Ms. Pete should be excluded. Dr. Rowe's opinions concerning Ms. Pete's alleged behavior, actions, and state of mind are untethered to reliable principles and methods and exceed her expert authority. The court should exclude them. First, Dr. Rowe inappropriately opined on diagnosis Ms. Pete purportedly suffers from with no basis. Experts are permitted only to provide opinions if their testimony is the product of reliable principles and methods. Though an expert need not have conducted her own test, her opinion must result from some reliable data that is comparable to the sources of medical data courts usually consider sufficient. Dr. Rowe's report violates this axiom by making a number of psychological assessments about Ms. Pete. For example, she accuses Ms. Pete of victim blaming, scapegoating, discounting complaints and rationalizing misconduct, committing institutional betrayal, and destructive leadership. Most egregiously, she opines that Ms. Pete possesses a dark tetrad of personalities, narcissism, antisocial tendencies, Machiavellian exploitation of others, and sadism. And at her deposition, she testified that Miss Pete showed symptoms of Alzheimer's as a very young woman. We talked about that. Based on a reading of Miss Pete's deposition transcript, though she flippantly excused her opinion by claiming she was kidding. Dr. Rowe's diagnosis of Miss Pete are wholly improper. She has never met Miss Pete, let alone performed a psychological examination of her, and she has not reviewed or ever saw any testing data or clinical reports concerning Miss Pete's psychology. Indeed, the only data points that Dr. Rowe relied on are Mr. Garcia's biased allegations against Miss Pete. Dr. Rowe's opinions are therefore entirely speculative or conjectural. Second, Dr. Rowe's conclusions regarding Ms. Pete's state of mind exceed her authority. State of mind is not an appropriate subject for expert testimony. Interesting. But Dr. Rowe offers no basis whatsoever for this conclusion. She was not present during the alleged events that she describes, and she has never met with or spoken to Ms. Pete. Her speculative determinations about Ms. Pete's motivations and intent should be disregarded. Dr. Rowe's opinions as to legal conclusions should be excluded. Dr. Rowe also impermissibly parrots legal conclusions drawn in Mr. Garcia's FAC. Doing so exceeds her role as an expert witness and should be precluded. Damn. They want you to fuck out of here, ma'am. On numerous occasions in her report, Dr. Rowe exceeds her authority in coming to legal conclusions. Most prominently, Dr. Rowe conclusively opines that the evidence reviewed in the case led her to infer that the defining characteristics of a toxic work environment were present, and she opines that Ms. Pete fostered a hostile work environment with emphasis added. These opinions are neither appropriate nor helpful to the trier of fact. It is the jury's job, after hearing all of the evidence at trial and being instructed on the law by the court, to determine whether a hostile work environment existed. This is not, however, the only instance in which Dr. Rowe invades the province of the jury. She also adopts Mr. Garcia's narrative of events and determines that they present just examples of the discrimination, harassment, and retaliation plaintiff endured. Like the existence of a hostile work environment, however, whether the Pete defendant's alleged acts constitute harassment or discrimination is not Dr. Rowe's verdict to decide. It is the court or the jury's. She should not be permitted to testify in this regard. And Dr. Rowe draws legal conclusions adopted from Mr. Garcia's complaint about his employment classification, stating that plaintiff was misclassified as an independent contractor while working as a personal cameraman to defendant Pete. But whether Mr. Garcia is properly classified as an independent contractor or an employee is a legal determination for the court or the jury, not Dr. Rowe. Dr. Rose should not be permitted to testify regarding this or any other legal determinations. Conclusion. The Pete defendants respectfully request that this court grant their Rule 702 motion and exclude from Dr. Rose's expert report and testimony any opinion, 1. As to the veracity of Mr. Garcia's allegations, 2. Regarding Mr. Garcia's credibility, 3. Regarding psychological assessments of Ms. Pete or her mental state, and 4. Regarding the existence of a toxic or hostile work environment or factors associated therewith. They want her completely stricken from the record. So basically, Emilio and his legal team went and found Dr. Rowe as an expert witness. Only Emilio was able to talk to her. Only the allegations in his lawsuit were presented to her. Anything concerning Megan directly, there was no interaction between herself and Megan. She had no interaction with Megan's deposition. Like, she just was only going off of the information presented, and she basically regurgitated it in her report. So it sounds like they hired her and she was, only acting in favor of what he was claiming. Here we have a filing also from 2 days ago. This is from Rock Nation, and they have filed a notice of motion for summary judgment. They say, please take notice that upon the memorandum of law, declaration of Desiree Perez, and the joint Rule 56-1 statement of fact submitted by defendants Megan P., Hot Girl Touring, Megan Thee Stallion, Rock Nation, all supporting documents attached here too, which are incorporated by reference in all prior pleadings and proceedings had herein, defendant Rock Nation by its undersigned attorneys hereby moves this court before honorable judge for an order on a date as to be determined by the court pursuant to Federal Rule of Civil Procedure 56, granting summary judgment as to all causes of action against Rock Nation and for such other and further relief the court deems just and proper. As set forth more fully in the accompanying memorandum of law, Rock Nation requests that summary judgment be granted in its favor and against plaintiff as to all causes of action asserted against Rock Nation. All right. Now, when I saw this, I said, I'm not a legal professional. What exactly is a summary judgment? So I came across this piece here. A summary judgment is a judgment entered by a court for one party and against another party without a full trial. In civil cases, either party may make a pretrial motion for summary judgment. For federal courts, Rule 56 of the Federal Rules of Procedure governs summary judgment. Under Rule 56, in order to succeed in a motion for summary judgment, a movement must show there is no genuine issue of material fact, and the movement is entitled to judgment as a matter of law. Okay? So Rock Nation wants to be left the fuck out of this. They want to be gone. And they want this to be determined against plaintiff Emilio to say, hey, Rock Nation has nothing to do with this. Right? Now, interestingly enough, there's also a partial summary judgment, which is a possibility as well. Judges may also grant partial summary judgment to resolve some issues in the case and leave the others for trial. For example, a judge might rule on some factual issues pre-trial, but leave the more complicated ones for trial. Alternately, a judge might grant summary judgment regarding liability, but still hold a trial to determine damages, which that's very much a possibility here, where the judge may say, hey, Rock Nation is not liable for any of this, but perhaps there could be damages. I'm not saying that that's what's going to happen. I'm just saying in terms of legal jargon, these are possibilities. Now, in addition to Rock Nation filing for summary judgment, they have a declaration here from Desiree Perez herself. All right. And, Desiree Perez is, a hot topic in a lot of different conversations right now. But here she's put this in. Ms. Desiree Perez says, she declares under penalty of perjury pursuant to 28 U.S.C. 1746 that the following is true. I am the Chief Executive Officer at Rock Nation, LLC. I've been employed by Rock Nation since 2008 and have been the CEO since December 2019. I have personal knowledge of the facts set forth in this declaration or knowledge of such facts based on my review and knowledge of Rock Nation's business records and files. Rock Nation is a limited liability company that provides management services to Miss Pete and many other artists and athletes. Okay, so here she's outlining the range of duties that they actually perform. Rock Nation is a full-service entertainment company managing some of the world's biggest musical artists and athletes since its founding in 2008. Rock Nation has grown into one of the world's leading entertainment companies and supports its diverse roster of talent via artist management, music publishing, touring, production, strategic brand development, and more. Rock Nation entered into an artist management contract with Megan Pete, professionally known as Megan Thee Stallion, in or around September 2019. In this role, Rock Nation supports Miss Pete's career as an artist and manages the business aspect of Miss Pete's musical career. While such role involves many things, it sometimes includes recommending options of vendors to Miss Pete based on our industry experience for her to choose from and coordinating professional events for Miss Pete. In addition, Rock Nation periodically provided first-level review of invoices sent to Miss Pete relating to projects managed for her by Rock Nation, such as invoices relating to a tour budget, which Rock Nation participated in creating. Rock Nation provided first-level review of invoices to ensure accuracy and completeness based on Miss Pete's agreement with each vendor before sending invoices to Miss Pete and her accounting company for approval and payment. All of these acts were undertaken subject to Miss Pete's express approval, as Rock Nation lacks authority to bind her without such approval or to actually approve payments on any invoices. Rock Nation was not involved in selecting Mr. Garcia as a photographer for Miss Pete, as their professional relationship predated Miss Pete's relationship with Rock Nation. After Miss Pete signed with Rock Nation would assist in coordinating appearances, photo shoots, tours, and other promotional events for Miss Pete, as is customary for managers to do. In some instances, when Miss Pete needed a photographer, she would reach out to Mr. Garcia directly to find out if he was available. In other instances, Miss Pete would advise Rock Nation which photographer she wanted, and Rock Nation would reach out to photographers on Miss Pete's behalf to find out their availability. So he was not the only photographer working with her either. When Mr. Garcia was booked for one of Miss Pete's events, employees of Rock Nation would sometimes communicate with him regarding logistics for the event, such as dates, times, and locations of the event. All such discussions that Rock Nation had with Mr. Garcia related to photography work to be performed by Mr. Garcia for Miss Pete, not for Rock Nation. Aside from discussing logistics, Rock Nation did not have the authority to control the manner and means of Mr. Garcia's work, such as which cameras he used or which photographs he took. There was only one instance I am aware of where Mr. Garcia performed photography services for Miss Pete at a Rock Nation office, as Miss Pete was using our office for a meet and greet session. Mr. Garcia never performed any services for Rock Nation anywhere. Miss Pete is not and has never been an employee or an independent contractor of Rock Nation. Okay? That's a narrative that a lot of people try to put out there. The people that don't like her, they try to make it seem like she's a Rock Nation slave or some sort of Rock Nation pawn. There's that. Rock Nation does not have any ownership interest in or legal affiliation with Megan Thee Stallion Incorporated or Hot Girl Touring LLC. So these are two businesses owned by Megan that Rock Nation has no ownership interest in or legal affiliation to. She completely owns them herself. Some people say, oh, Rock Nation's lawyers helped her register it, so Rock Nation owns it. That's not how that works. The company don't get ownership just because a lawyer helped you file paperwork for it. What are you talking about? Rock Nation is not a franchisee or franchisor of Megan Thee Stallion Entertainment Inc. or Hot Girl Touring LLC. From 2020 to June 2023, Mr. Garcia was not the only photographer Miss Pete used, and in some instances, Miss Pete instructed Rock Nation to book photographers other than Mr. Garcia when she needed them. And if you see, they got with her September of 2019. From 2020 on up, she's had these companies, I guess. So they've set her up for success and not taking ownership of her shit. Because some companies, management companies, if they helping you to secure your paperwork, they will take your shit. But you're going to see their names in that motherfucker. Anyway. At all times, Rock Nation followed Miss Pete's instructions as to which photographer Miss Pete wanted to use and did not have the authority to contradict Miss Pete's instructions. So this is all at her request. 19. Rockefeller Capital Management is not affiliated with or owned in whole or in part by Roc Nation. Okay? This is Rockefeller. You see that? Not Rockefeller, but Rockefeller. Similarly, Rockefeller Capital Management does not own any portions of Roc Nation. And that's a name that predates both Roc Nation and Rockefeller Records. Roc Nation did not have the authority to approve payment to Mr. Garcia or anyone else without Ms. Pete's express approval, nor did it have the authority to refuse to pay an invoice that was properly coded and submitted and approved by Ms. Pete. In August 2022, Mr. Garcia submitted a number of invoices which incorrectly charged his weekly rate for weeks in which he was not traveling or present with Ms. Pete. When I was added to an email chain about his invoices to Ms. Pete, I responded, as Ms. Pete is an important client to Roc Nation. I advised Mr. Garcia that, consistent with the rate structure agreed between him and Ms. Pete would not approve payment for weeks in which he did not perform work for Ms. Pete. Now, if you've been keeping track with this case on my channel, the incident at question here is there was a period of weeks in which Emilio was not traveling with Megan Thee Stallion. So during that time period, he was not working as a cameraman. He was not taking photos. He was not doing any of the like. Okay? During those weeks, he was only performing editing services from the comfort of wherever he was. Therefore, they did not agree to pay him his full rate that he would normally be paid for traveling with Megan, taking photos of Megan, and editing, all while being in her atmosphere. They say, shit, you staying home, you're not fully participating in your duties. Therefore, we will not fully pay you the same rate. And editing is different than taking photographs and editing. That's two different charges. He wanted full payment. So I and others at Roc Nation communicated with Mr. Garcia and his attorney for approximately 3 months around this time to assist them in getting the invoices complete correctly so that Mr. Garcia could get paid by Ms. Pete. Based on a discussion I had with Ms. Pete in or around June 2023, I understood that she no longer wished to work with Mr. Garcia, and he was thus no longer asked to provide photography services. There are no written agreements between Mr. Garcia and Roc Nation. Roc Nation never paid Mr. Garcia for any work performed for Ms. Pete. All right, so this is where they absolve themselves of any liability or connection to his pay or how he was paid, because they only move at the direction and discretion of Megan. Mr. Garcia never performed any work for Roc Nation, and Roc Nation has never paid Mr. Garcia for any work performed. Mr. Garcia never issued an invoice addressed to Roc Nation. And I think what Emilio and his legal team, perhaps they don't know, or perhaps they're purposely overlooking this, is that Megan Thee Stallion is not a signed Roc Nation artist. So they're not functioning as a label for Megan Thee Stallion. And if she was possibly signed as an artist on the Roc Nation label, which has since been dissolved, they probably would have some level of liability because she would be their recording artist, in which they own portions of her music and own portions of these different things that she's involved with. But because they only manage her, they're not as intimately involved as they would be if she was a signed artist to a label. And I think they're misidentifying and misrepresenting that professional relationship in order to find a reason or a way to get money out of Roc Nation, because of course they're the bigger fish than a Megan Thee Stallion. Mr. Garcia never issued an invoice addressed to Roc Nation. Mr. Garcia did not receive employee benefits from Roc Nation at any time. Roc Nation did not issue any tax forms to Mr. Garcia. Rock Nation has never possessed any employment records relating to Mr. Garcia. I hereby certify under penalty of perjury that under the laws of the United States of America that the foregoing is true and correct. So that's Desiree Perez once and for all, setting the record straight. Homie, we don't even really know you. And we wouldn't know you if she had never brought you around. So here we have paperwork filed yesterday, and this is Megan Thee Stallion, Hot Girl Touring, Megan Thee Stallion Entertainment, and Rock Nation's statement of material facts pursuant to Local Rule 56.1 in support of their motions for summary judgment. Remember, we talked about summary judgment. Rock Nation and Megan are pushing for a summary judgment. They want to get this shit tossed. They want to get this over with without having to go to trial. So defendants, Megan Pete, Hot Girl Touring, blah, blah, blah. These are the parties and their involvement. Megan Pete is a musician. We know that. We don't need to get into all that. Hot Girl Touring is Megan's LLC for taking payments for her live performances and for paying independent contractors for their services related to those performances. Megan Thee Stallion Entertainment is Miss Pete's corporation responsible for intaking payments from her public appearances and business deals outside of touring and performing, and for paying independent contractors for their services related to those assignments. These are companies she owns herself. Rock Nation, we know who Rock Nation is. We really don't got to get into that. We know the nature of the relationship. They started managing her in September of 2019. Desiree Perez outlined this very clearly. Now, as for plaintiff Emilio Garcia, he's the one suing. He's the cameraman. He lives in Texas. He only recalled filing personal tax returns in Texas. Of course, remember, he tried to file this under California law. And they're saying, how you filing this in California when you're a resident of Texas? You only been paid in Texas. You only lived in Texas. And they're also trying to get his New York allegations under New York law for business practices to be tossed as well. When he left Texas for travel or to perform photography services, Mr. Garcia always intended to return home to Texas. Mr. Garcia is also a homosexual male. That is important to note because he is filing allegations of being discriminated against for his sexual preference. In 2011, Mr. Garcia began performing photography services. Since 2013, Mr. Garcia uses his social media accounts such as IG, Facebook, Twitter, TikTok, etc. to solidify photography and videography clients under the name Emilio Cucci. That is also his artist name, because he's also a whack rapper, in my opinion. Mr. Garcia provided services to Miss Pete from January 2018 through January 2023. From January 2018 to August 2019, Mr. Garcia performed photography services for Miss Pete for free. Damn. So that's almost 2 years that he was working for Megan completely for free. Now remember, they were friends. Mr. Garcia did not mind performing his photography services for Miss Pete for free because he wanted experience. In August 2019 through at least October 2019, Mr. Garcia began invoicing Miss Pete's former label, 300 Entertainment. See, former label. He was used to working with the label. But at a certain point, things went to Rock Nation management. But I think he misunderstood the extent. For photography and videography services rendered to Miss Pete and related expenses. Rock Nation was not involved in selecting Mr. Garcia as a photographer for Miss Pete, as their relationship predated Miss Pete's relationship with Rock Nation. At all times, Rock Nation followed Miss Pete's instructions as to which photographer Miss Pete wanted to use and did not have the authority to contradict Miss Pete's instructions. On March 1st, 2020, Mr. Garcia signed a long-form written agreement with HGT, and of course, HGT is Hot Girl Touring. Miss Pete executed the agreement as HGT's authorized signatory. The agreement stated that HGT engaged Mr. Garcia as an independent contractor to provide photography and videography and editing services, including retouching services to be used in any manner or medium worldwide in perpetuity. So it sounds to me that Roc Nation informed Megan that the label should not be paying him. If he's your personal guy, figure out how to pay him direct, right? And so she followed suit. They are her management company, so they gave her best business practices for independence. Bum, bum, bum. To be used in any manner, medium, worldwide in perpetuity. The agreement further provided that nothing herein contained shall constitute a partnership, joint venture, or other agency relationship between Mr. Garcia and HGT, that Mr. Garcia was performing his obligations hereunder as an independent contractor. They also have his independent contractor contract that he signed. We showed that months ago as well. But now he's claiming he shouldn't have been identified as such. And that he shall be solely responsible for and shall pay all taxes required to be paid in connection with the compensation payable to him under, including payroll taxes and contributions. Mr. Garcia agreed that he shall not hold himself contrary to the terms of this paragraph, although he's doing so right here in this complaint. Okay? In full consideration of Mr. Garcia's services, HGT agreed to pay him $5,500 per month. So he was making roughly $70,000 a year, or somewhere close to it. Okay, not to mention travel and other expenses of him being on the road, being paid for, chef providing meals from Megan. So I would assume the value of what he was doing was also higher than what his salary was indicate. Roc Nation is not a signatory to the independent contractor agreement, and Roc Nation is not named as a beneficiary or otherwise included in the independent contractor agreement. Mr. Garcia does not have any written agreement between himself and Roc Nation. Between spring and fall 2020, Ms. Pete rarely required Mr. Garcia's services. Damn. This was a result of both the COVID-19 pandemic, which led to the cancellation and delay of live performances, and an incident in summer 2020 where Ms. Pete was shot, resulting in trauma that led Ms. Pete to retreat from working as frequently. Ms. Pete still earned revenue during this time. Some opportunities resumed in the last quarter of 2020, and Mr. Garcia began rendering services for HGT from October through December 2020. Mr. Garcia continued to render services for HGT from 2021 through May 2022. From 2020 to 2023 June, Mr. Garcia was not the only photographer Ms. Pete used, and in some instances, Ms. Pete instructed Roc Nation to book photographers other than plaintiff when she needed them. At all times, Roc Nation followed Ms. Pete's instructions as to which photographer Ms. Pete wanted to use and did not have the authority to contradict Ms. Pete's instructions. In some instances, when Ms. Pete needed a photographer, she would reach out to plaintiff directly to find out if he was available. In other instances, Ms. Pete would advise Roc Nation of which photographer she wanted. On June 1st, 2022, Sam Riddle, a former manager at Roc Nation, notified Mr. Garcia that Rockefeller Capital took over management of Ms. Pete's business entities and that all future invoices should go to a new Team Megan Rockefeller Capital email address. Okay? So it sounds like she got with a financial management company that started taking over her business financials. Okay? As she's evolving. Mr. Garcia responded that he discussed a rate increase with Ms. Pete and looped in his attorney, Amin Meziani, to negotiate the terms of the rate increase. Ms. Meziani proposed a weekly rate of $2,884.61 for weeks Mr. Garcia rendered services starting on June 1st and lasting for 1 year. Ms. Meziani also proposed a $75 per diem and 3 days off per month. Okay, so he no longer wanted $5,500 a month. He now wanted $2,800 a week, which would put him in the realms of $9,000 a month. So almost double. On June 20th, 2022, Ms. Pete approved Mr. Garcia's proposed terms, and Mr. Riddle communicated her agreement to Mr. Garcia and his counsel. Mr. Riddle asked Mr. Garcia's counsel to prepare a written agreement reflecting the new terms, writing, "May need to get the long form of things right, but possible to send over an agreement, and we'll send back any comments, language that we need in there." Neither plaintiff nor his counsel ever provided a revised agreement reflecting the new terms. So they were supposed to write this up contractually, but they're saying that agreement never came through. When Rockefeller Capital took over as Ms. Pete's accounting team, it implemented a more detailed and streamlined process for reviewing and approving Ms. Pete's increasing number of invoices. Under Rockefeller Capital's new process, Roc Nation would run a first-level review of invoices to ensure the invoices were accurate and properly coded, then would pass them along to Ms. Pete for her approval of payment. When Ms. Pete approved payment, Rockefeller Capital would process payment to each vendor. Okay, so this is basically taking some of the responsibility off of Megan to process payment to Emilio as she's becoming a bigger star, more activity, getting back into touring, all of the activity that took place, as COVID was being ushered out of the conversation. Artists were getting back on the road, getting back to putting out music. Megan in particular, her financial management team implemented new policy to say, hey, we just need you to approve the payment. We will take care of the rest. All right. Roc Nation's going to review everything, make sure it's correct. They run it by you. Once everything is good, we will process the payment. Okay. To all of your vendors. Rockefeller Capital is not affiliated with, owned in whole or in part by Roc Nation. Similarly, Rockefeller Capital does not own any portion of Roc Nation. Prior to Rockefeller Capital, Ms. Pete's financial and accounting affairs were managed by MBAF BDO. Roc Nation has never been responsible for paying Ms. Pete's vendors. Roc Nation did not have the authority to approve payment without Ms. Pete's express approval, nor did it have the authority to refuse to pay an invoice that was properly coded and submitted and approved by Ms. Pete. Prior to Rockefeller Capital's taking over her accounting functions, Roc Nation was not involved in reviewing Ms. Pete's invoices. Mr. Garcia continued to provide photography, videography, and editing services to Pete and invoiced her for his July 2022 services at his new rate. In August 2022, plaintiff submitted a number of invoices which incorrectly charged his weekly rate for weeks in which he was not traveling or present. Okay, so they had even started paying him his new rate, but then he took some time away. And this is where things went left, because he thought he was going to keep getting that extra payment to go from around $5,000 to around over $9,000 per month comfortably, but then trying to perform less work for more pay. Megan and Roc Nation said, no way. Okay. Roc Nation CEO Desiree Perez, on behalf of Ms. Pete, responded to plaintiff that consistent with this rate structure agreed between plaintiff and Ms. Pete would not approve payment for weeks in which plaintiff did not perform work for Ms. Pete. Plaintiff then noted that on certain weeks when he was not present with Ms. Pete, he performed editing work remotely. Ms. Perez responded that Ms. Pete did not approve him making the same weekly rate for weeks when he was performing remote editing work as when he was physically with Ms. Pete. I don't see how hard to decipher that is. Ms. Perez further advised plaintiff and his attorney, I don't want to suggest pricing. You should advise what that is, but it cannot be the same as being present. As far as what happens on edits, I don't want you to deny doing the work and happy to compensate you. Let's agree on the rate. So she says, it cannot be the same, but I don't want to say how much it is. You should come up with that price, but you will not be able to receive the same rate for doing lesser work. Ms. Perez further clarified, process is you turn your invoice in, I review, then it goes to Meg to approve, then it's wired. The same day, plaintiff submitted revised invoices reflecting only the dates he performed work with Miss Pete. In September 2022, plaintiff again submitted invoices that contained incorrect or insufficient information. In order for Rockefeller Capital to accurately track Miss Pete's expenses, it needed all vendors to specify which projects, tours, events they were billing for, which plaintiff had not done. Mr. Sean Mulvihill, Roc Nation's then CFO, contacted plaintiff to inform him that his invoices needed to identify the dates he performed services, the assignments performed, and the tour leg he performed on. All right? So they're saying, hey, man, you got to be more specific about what it is that you're doing here. Plaintiff made the necessary corrections, and Mr. Mulvihill advised plaintiff that the invoices would be sent to Ms. Pete for approval. Plaintiff's attorney and Mr. Mulvihill had a small amount of additional discussion in the first half of October relating to plaintiff's per diem allowance, which was resolved by October 13th, 2022. Roc Nation communicates. So now it's getting a little complicated here. You know, he was getting paid his rates. Then it sounded like he started trying to jug and maneuver, trying to keep that same rate for doing less work. Then not being specific about where he was and what he actually did. They got through it. He got paid his portion. But as you can see now, there's a contentious relationship. He don't like dealing with Roc Nation and Rockefeller Capital. He like, man, what happened to Megan? Roc Nation communicated with Mr. Garcia and his attorney for the 3-month period following Rockefeller Capital taking over as Miss Pete's financial team, which coincided with plaintiff's request to adjust his rates to assist them in getting the invoices completed correctly so that Mr. Garcia could get paid by Miss Pete. On August 25th, 2022, Miss Pete's tour manager, Samantha Pauly, introduced Elizabeth Saravo to Miss Pete's team of independent contractors. Okay. Beth took over as Miss Pete's camera person. Ooh. So now we got the introduction of Miss Beth. I didn't know about this part. So now your replacement is starting to come through. Beth took over as Miss Pete's camera person for the remainder of her European tour when Mr. Garcia returned home to Houston after Miss Pete's performance in Leeds. Beginning in fall 2022, Miss Pete took a break from live performances and public appearances due to the emotional distress she felt in preparing for the criminal trial of the man who shot Miss Pete, Daystar Peterson, set for December 2022. Remember the trial. For example, she canceled her scheduled Australian tour scheduled for November 2022 to focus on her mental health. Miss Pete continued to earn income during this time. Of course, she's got music out and endorsements and things. So remember, he said that he wasn't booked much after September. They're showing, yeah, he wasn't booked much because Megan had canceled her tour. The cancellation of tour dates and other events meant less opportunities for Mr. Garcia to provide his services to Miss Pete. Mr. Garcia wasn't booked much after September. That's his quote. So now they're making sense of the gaps that he is trying to take advantage of. From November 2022 through February 2023, Mr. Garcia only invoiced Miss Pete for 1 day in November for services performed in Los Angeles, 7 days in December for services performed in Los Angeles and Miami, 2 days in January for services performed in Miami, and 4 days in February for services performed in Los Angeles, totaling 14 days over 4 months. Shit, boy, you did 14 days of work in 4 months. Yeah, I can see why you were starting to squirm and look left and right, because the checks weren't coming in. Indeed, from September 2022 through June 2023, plaintiff only invoiced for 15 projects in places like Texas, Japan, Europe, Brazil, Nevada, and California. From February 2022 through June 2023, Mr. Garcia only worked in New York on 3 occasions. Miss Pete's February 2022 birthday party, a week in May 2022 around the Met Gala, and Miss Pete's May 3rd and 5th performances in New York City, and a 4-day stretch in August between the 10th and the 13th. Miss Pete's personal assistant offered Mr. Garcia another assignment in New York in August of 2022, but Mr. Garcia declined it because he lost his ID and couldn't fly. Additionally, during this period, Beth became Miss Pete's preferred photographer over Mr. Garcia because Miss Pete really loved the way she took her pictures and wanted a better photographer than Mr. Garcia, which is not against the law. Mr. Garcia's final assignment performed was related to Miss Pete's Essence video shoot. Essence magazine, I would presume. While on a trip in Milan with Alejandra Garcia in June 2023, Miss Pete discovered insulting text messages sent between Mr. Garcia and Alejandra Garcia about Miss Pete's appearance. And called Mr. Garcia from Alejandra's phone. Okay, so she discovered that he been talking shit. When Miss Pete saw the text messages, she felt hurt and betrayed because she considered Mr. Garcia to be like family and did not understand why he would make hurtful comments about her. Both Mr. Garcia and Alejandra apologized to Miss Pete about the insulting text messages. So what the hell was Alejandra saying? Because both of y'all was talking that shit. After the call, Miss Pete decided to no longer interact with either of them. So this is what got you cut off. In June 2023, Mr. Garcia's 1-year negotiated term expired, noting 1-year term effective June 1st, 2022. While a Roc Nation representative requested Mr. Garcia's availability to potentially provide videography services for Miss Pete at the Essence Fest in New Orleans, she later informed Mr. Garcia that the team decided to go with a different direction for videography. Based on a conversation with Miss Pete, Roc Nation understood that Miss Pete no longer wanted to work with Mr. Garcia. Because plaintiff was booked for projects on an as-needed basis, he was not officially terminated, nor did Roc Nation have the authority to terminate him. He simply was not booked for future projects. All right? So his contract expired and communication began to cease. The friendship was already tarnished. Megan said, fuck him. Furthermore, Mr. Garcia rendered services for the Pete defendants as independent contractor, all right, which we've talked about before. Mr. Garcia engaged other clients, focused on his performance artist career, and could reject assignments due to his unavailability. Now, remember, in his lawsuit, he claimed that he worked around the clock for Megan Thee Stallion and that she had some sort of non-compete that would restrict him from working with other clients. That is his allegations in his complaint. Here, they say Mr. Garcia rendered services to other clients unassociated with Megan. When Miss Pete slowed down on work in 2020 due to the COVID-19 pandemic and being shot, Mr. Garcia photographed Houston rapper Paul Wall, baby. Graduates from the 2020 class in Houston, weddings, and family portraits. In January 2022, Mr. Garcia photographed the drag artist Vitamin B. Y'all remember when I went through his Instagram and showed y'all? I'm like, this man said he couldn't shoot no photos for nobody else, but he got an Instagram full of photos he did for a lot of somebody else's. Mr. Garcia photographed and did editing for JT. Oh, shit. A female rapper, not JT. Damn. You went and did some work with the ops. I don't know if they was ops yet, though. But he also was allegedly in contact with Nicki. This ain't a part of the lawsuit, though. After Mr. Garcia returned from Europe in August 2022 and Miss Pete canceled her Australian tour, Mr. Garcia solicited photography and videography clients. He sought out freelance photography and videography opportunities because he needed some sort of income, and Miss Pete wasn't booking anyways. Sounds like deposition questions. During the 2022 fall season and through 2023, Mr. Garcia contacted a Roc Nation employee on 2 different occasions to see if anyone on his roster needs any type of content and noted that Meg has been on break and I need some work. So he actually decided to reach out to Roc Nation like, damn, if Megan ain't active right now, let me see if any other Roc Nation artists need a photographer, which I don't see that as a bad thing, but your words are coming back to bite you. He posted on his social media accounts open calls for anyone interested in Christmas 2022 photos and noted that he still does local shoots when I'm in Houston if anyone is interested, which contradicts his complaint. He promoted the mobile photo booth he co-operated with his ex-boyfriend known as the Coochie Booth. Terrible branding. And pitched his social media followers for bookings during the 2022 holiday season. He photographed Sticky Lauren, a social media personality in Houston. He promoted his availability to do photography work at Los Angeles Pride Festival. At the multi-day festival, Mr. Garcia provided photography and videography services to Princess Nokia, a female rapper, and invoiced her for his services. Mr. Garcia also provided Miss Pete services during the same event. So that also directly contradicts that he couldn't work for anybody else while he was working for Megan, because at the Pride Fest in LA, he photographed Megan and Princess Nokia at the same event. He photographed Darren Cow, Quinitra Jones, and others and received income for performing those services during this time. Mr. Garcia continued providing photography and videography services to Miss Kyle and Jones through 2024. He advertised his services for maternity photo shoots. In addition to photography, Mr. Garcia is also a performance artist and rapper who performs live under the stage name Emilio Coochie. Mr. Garcia's singles include Bump, Itis, and Pac-Man. On August 28, 2021, which is during the time that he was actually working with Meg still, he performed a paid gig in Houston for Music and Drag, an LGBT experience. I also noted this earlier in the year. By taking this gig, Mr. Garcia was unable to perform he was unable to perform services for Miss Pete on that date, meaning he took that day off, which also contradicts the fact that he wasn't able to take off days. Also in his complaint. On March 24th, 2022, Mr. Garcia performed at the Houston Artist Spotlight. Indeed, there were times Mr. Garcia rejected Miss Pete's assignments because of a prior booking or other unavailability. For example, on February 19th, 2023, Mr. Garcia told a Roc Nation representative that he was not available March 13th through 19th due to prior booking. So they're poking all the holes in his story where he said he was not allowed to do this extra work. They're showing all the instances in which he actually did, which a simple peruse through his Instagram showed me that, but they're showing dates and times. When Mr. Garcia stopped performing photography, videography, and editing services for the Pete Defendants in June 2023, he continued to photograph musicians and rappers including Paul Wild Baby, Maxo Cream, Mona Leo, Ken the Man, That Mexican Cannot, or is that supposed to be the Mexican OT? Mike Dimes and D Baby during Spotify Rap Caviar Most Necessary Houston Showcase. Pop artist Kim Petras, from whom he received payment from and promoted on his social media. Sunny the Rapper. Mr. Garcia had creative direction over his work and controlled how he rendered photography services. Whenever Mr. Garcia filmed Miss Pete, he decided the means by which he provided services, such as the instruments he used, how to shoot video and photography, and how to edit them. Miss Pete just hired him to take my pictures and my videos. That's a quote from Megan. Miss Pete did not consider herself to be Mr. Garcia's boss. Mr. Garcia chose which cameras to purchase and use. Neither Miss Pete nor anyone that worked at HGT, MTS, ENT, or Roc Nation told Mr. Garcia which cameras to purchase and use. For example, on May 12, 2022, Mr. Garcia sent Mr. Riddle a list of equipment he required, including a clamp medium, RE LED Sky Panel S60C Big Ben, FOBA ball head with QR plate, Gitso S3 carbon fiber tripod with column and crank, medium roller, and sandbag. Mr. Garcia still owns the cameras he used to shoot Miss Pete and never returned them to the Pete Defendants or Roc Nation. Mr. Garcia also chose which editing software to purchase and use on his projects for Miss Pete. Neither Miss Pete nor Roc Nation provided him photography, or videography training. Mr. Garcia directed how videos should be edited. For example, Mr. Garcia filmed and edited a series of videos Miss Pete posted to YouTube titled Hottie World and was credited as its creative director. Noting Emilio Cucci as Hottie World creative director. Additional BTS. Mr. Riddle told Mr. Garcia that Hottie World was Mr. Garcia's project to manage and lead and direct and make special. Accordingly, Mr. Garcia directed the edits he wanted, including blurring the hair product or cutting out that clip completely, and pushed back on edits suggested by another Roc Nation manager, telling Mr. Riddle he doesn't think it's necessary. Mr. Riddle responded, "Okay, cool, thanks." As creative director, Mr. Garcia stated that he had been guiding another individual through the creative side of the Hottie World videos under his discretion. Mr. Garcia also filmed Miss Pete in various cities that at times she posted to her social media accounts. Mr. Garcia was in control of how to edit video content for the travel videos as well. For example, when discussing a video reel to post of Miss Pete in Japan, Mr. Garcia created 2 different versions to present Miss Pete, one with and without the little purple hearts. I was going to do dinner separate so I can pull all the clips of everyone together. Miss Pete approved Mr. Garcia's creative direction for his dinner reel idea. Yes to dinner separate. In another instance, a Roc Nation employee requested Mr. Garcia send some raw footage from a shoot he had done earlier that day, and Mr. Garcia refused to provide any raw footage until Miss Pete approved it. While Mr. Garcia retained control over how to shoot and edit content, Miss Pete would approve what content she chose to post. When Mr. Garcia was assigned to a project from Miss Pete, he would sometimes receive an assignment sheet from the Pete defendants. The assignment sheets merely provided logistics information such as addresses, contact info, call times. They did not include directions on how Mr. Garcia was to perform his photography. When Mr. Garcia was booked for one of Miss Pete's events, employees of Roc Nation would communicate with him regarding logistics for the event, such as dates, times, and locations of the event, and all such discussions that Roc Nation had with Mr. Garcia related to photography work to be performed by Mr. Garcia for Miss Pete, not for Roc Nation. Aside from discussing logistics, however, Roc Nation did not have the authority to control the manner and means of plaintiff's work, such as which cameras he used or which photographs he took. So they weren't giving him directives, right? And the one time that they did suggest an edit, he said no. They said, okay, cool. There was only one instance that Roc Nation is aware of where plaintiff performed photography services for Miss Pete at a Roc Nation. Remember the meet and greet thing that Desiree Perez was talking about. Mr. Garcia brought his ex-boyfriend, Joshua Sanchez, to assist him with his photography assignments for Miss Pete at least 5 to 10 times. Mr. Sanchez would assist by setting up lighting and recording video while Mr. Garcia was taking photos. And Mr. Garcia instructed Mr. Sanchez on what he wanted him to do. Okay, that's interesting. I wonder if Megan was also paying for Sanchez to be there. I don't know. Mr. Garcia was not responsible for filming Miss Pete's magazine cover shoots or other promotional opportunities, nor did Mr. Garcia shoot Miss Pete's music videos. Mr. Garcia did not have a defined role. He took pictures, he took videos, but there was never like a definitive purpose of what the images or videos were going to be used for. So it was mostly behind the scenes footage and live footage and the occasional TikToks and things of that nature. Mr. Garcia set his own schedule. He set his own schedule by providing his availability and agreeing to assignments, which also contradicts the fact that he had no personal time for himself. Mr. Garcia confirmed there are times he will focus on his own personal plans before editing a project for Miss Pete. For example, after Miss Pete's former manager, Mr. Riddle, asked Garcia for edits to a video, Garcia responded, yeah, it'll probably be after the movies though, most likely. So he was at the movies doing his own thing. He wasn't at the beck and call. In another instance, while traveling with Miss Pete in New York's in May 2022, Mr. Garcia described his plans and the flexibility of his schedule when working, noting that he and his boyfriend were probably going to work out first in the next hour, and then after we can go eat somewhere. I just want to take him to Times Square real quick too, because he never been. Alejandra Garcia, Miss Pete's former freelance makeup artist, responded that the two should go on a carriage ride in Central Park. Later that day, Alejandra Garcia asked if Mr. Garcia and his boyfriend would be down to do dinner and a drink. Mr. Garcia responded, "We have been asleep all day, about to shower and get dressed. Right now, I just want to say, hold up, but I just want to swing by Times Square for him still. LOL. Then we can Uber to a restaurant. Nanika, the director, is doing karaoke at 9 too if we want to join." In a different text message exchange, Miss P asked Mr. Garcia what he was doing, and he responded that he was being a tourist with my mans, 3Zs. When Miss P asked if Mr. Garcia and his boyfriend wanted to go bowling, Mr. Garcia responded, "Oh, yes, what time?" and said that the two would be there in 30, which shows he had the right to decline if he so chose. Mr. Garcia also confirmed that there were times he could not render services for Miss Pete because he had scheduled a prior booking. Mr. Garcia would also regularly choose to stop providing services in person with Miss Pete to go back home to Houston for personal reasons. On November 4th, 2020, when Mr. Riddle asked Mr. Garcia if he was at Meg's, Mr. Garcia responded, "No, I came home to vote and for my boyfriend's B-Day this week." Mr. Riddle replied, "No worries." On August 19th, 2021, Mr. Garcia notified Mr. Riddle that he was unavailable to render services for Miss Pete's August 28th New York event because he had his own performance in Houston that same date. On February 20th, 2022, Mr. Garcia informed Mr. Riddle that he would be unavailable March 24th through 28th because he was moving apartments. In August 2022, Mr. Garcia decided to leave Miss Pete's European tour to return home to Houston. Mr. Garcia invoiced for services rendered, received 1099 tax forms, and wrote off photography equipment as a tax expense. To receive payments for services rendered, Mr. Garcia invoiced HGT and MTS using his personal letterhead, which included his brand name Emilio Cucci, address, bank info, and short description of services performed. For the 2020 tax year, Mr. Garcia invoiced HGT for a week of services performed in August and associated incidentals. He also invoiced for services performed in October, November, and December 2020. Mr. Garcia was paid his 2020 services and received a 1099 tax form from HGT for the year. For the 2021 tax year, Mr. Garcia invoiced for services rendered. HGT paid Mr. Garcia for his services in 2021, and Mr. Garcia received a 1099 tax form from HGT. For the 2022 tax year, Mr. Garcia invoiced for services rendered. Beginning in July 2022, Mr. Garcia invoiced on a per-project basis. Mr. Garcia was paid for his 2022 services and received a 1099 tax form from HGT and MTS. For the 2023 tax year, Mr. Garcia invoiced for services rendered on a per-project basis through June 2023. He was paid for his 2023 services, okay, and received a 1099 tax form. Sometimes Mr. Garcia did not invoice the Pete defendants at all, but rather Miss Pete's former label, 300 Entertainment. Mr. Garcia never received a 1099 or W-2 tax form from Roc Nation, nor represented to his taxpayer that he was Roc Nation's employee. Mr. Garcia wrote off his photography and videography equipment on his tax returns. Mr. Garcia could not recall ever telling the IRS that he was an employee of Miss Pete, HGT, MTS Entertainment, and Roc Nation either before or after he retained counsel. But it wasn't until he got with his lawyers that he then said, "Well, I worked for all of them." When Miss Pete approved an invoice of plaintiffs, her accounting company would process payment to him. Beginning in June 2022, plaintiff's accounting team was Rockefeller Capital Management, which has no affiliation to Roc Nation. Roc Nation never paid plaintiff for any work. We've stated all this before. Roc Nation wasn't responsible for none of this shit. Mr. Garcia did not complain about his work environment. Okay? So this is the February 2022 birthday celebration. I believe this was at the strip club. This is the situation that he has complained about in his lawsuit. They are now pointing out that at the time of this happening, he had no complaints. On February 15, 2022, Mr. Garcia attended Miss Pete's surprise birthday party in New York. As part of the festivities, Miss Pete, Mr. Garcia, and others went to a strip club called Sapphire. At some point, Mr. Garcia just walked out of the strip club. Mr. Garcia did not tell Miss Pete at any point that he believed going to a strip club in New York was unlawful, discriminatory, retaliatory, or harassing. Mr. Garcia also cannot recall telling any individual associated with HGT, MTS, or Roc Nation the same. While Mr. Garcia told 3 individuals, his ex-boyfriend Joshua Sanchez, a photographer Aaliyah Rios, and Miss Rios' mother Erica Lopez, that he believed going to a strip club for Miss Pete's surprise birthday party constituted harassment, he knew that none of these individuals were supervisors or managers of HGT, MTS, ENT, or Roc Nation. Okay? That's interesting. The 2022 vacation to Ibiza. On June 13th, 2022, Miss Pete, Mr. Garcia, Alejandra, Miss Pete security guard Mike Madeline, and others traveled to Ibiza, Spain for a 10-day vacation. Miss Pete and Mr. Garcia stayed at a rental home in Ibiza. On June 17th, Miss Pete's college friends Jayla Mitchell, Darren Kyle, and Quinitra Jones arrived in Ibiza. On the night of June 19th, Mr. Garcia, Miss Pete, Mitchell, Kyle, and Jones went to a dinner and a nightclub. So now we have names of who were there. After the nightclub, Mr. Garcia and Miss Pete, Mitchell, Kyle, and Jones took a chartered vehicle back to the rental home. There were no Roc Nation employees in the vehicle on this night. During the drive back to the rental home, the group was dancing to music and laughing. Something's been redacted here. No one reacted in a shocked or surprised manner. The group continued to laugh during the car ride home. I don't know what this is that's redacted though. Mr. Garcia did not complain to Ms. Pete or anyone associated with HGT, MTS, and Roc Nation that he believed any acts that occurred in the vehicle were offensive, unlawful, discriminatory, or constituted harassment. This is interesting though with that blacked out piece. I ain't gonna lie, I don't know what that is. Nor did Mr. Garcia discuss what happened in the car with Miss Cal or Alejandra. Mr. Garcia alleges that while in Ibiza, Miss Pete made comments to him that amounted to fat shaming. Miss Pete denies those allegations. In any event, Mr. Garcia did not complain to Miss Pete or anyone affiliated with HGT, MTS, or Roc Nation about alleged comments she made to him regarding his weight, nor did he notify them that he thought those alleged comments were inappropriate. Mr. Garcia conceded that any complaints Roc Nation was made aware of from the trip related only to alleged acts directed at Alejandra, not him. Mr. Garcia also confirmed that none of what occurred in Ibiza impacted him in New York or California. Interesting. And of course, he's got complaints under New York and California law. Miss Pete's European tour after Ibiza. Mr. Garcia alleges that while in Portugal in 2022, with Miss Pete as part of her European tour, Miss Pete threw a remote control at him while in a hotel room together. Miss Pete denies this event occurred. In any event, Mr. Garcia never told Miss Pete or anyone affiliated with the companies that Miss Pete engaged in conduct that constituted harassment or discrimination. Mr. Garcia confirmed that none of what occurred in Portugal impacted him in New York or California. Mr. Garcia's March 2020, August, and September 2022 payments. In March 2020, Mr. Garcia sent Pete's former managers Sam Riddle and Gilly Liar a series of emails regarding a delay in payments. In August and September 2022, Mr. Garcia again sent Roc Nation a series of emails regarding his payments. Mr. Garcia did not write in the March 2020 or August and September 2022 emails that he believed the delay in his payments was due to a discriminatory or unlawful reason. Mr. Garcia was paid for his March 2020 services. Mr. Garcia was also paid for his August and September 2022 invoices and confirmed it to Miss Pete's manager, T. Ferris, and Roc Nation's Sean Moville. So how you going to complain about something and say it was discrimination when they paid you? Miss Pete's Austin, Texas performance and June 2023 phone call. Mr. Garcia claims that Miss Pete allegedly made a comment to his ex-boyfriend, Joshua Sanchez, that Mr. Garcia believed targeted him as a homosexual male while Mr. Garcia was in Austin, Texas. Mr. Garcia also claims that Miss Pete made another comment directed at his sexuality on the June 2023 phone call. Miss Pete denies making those alleged comments. Miss Pete does not have any animosity towards the LGBTQ community. Everyone on Miss Pete's team is either gay or bisexual, and Miss Pete herself is bisexual. Now it's on paper. We've been talking about this the entire time. It is now on paper. Mr. Garcia confirmed that hairdressers, makeup artists, and others would attend. Miss Pete confirmed the invitation was just open. You did my hair, you did my makeup. If you want to come to the event, you can. Mr. Garcia's ex-boyfriend, Mr. Sanchez, also denied that Miss Pete made a discriminatory comment to him. So even the boyfriend said that never happened. Mr. Garcia never told Miss Pete or anyone affiliated with HGT, MTS, or Rock Nation that he believed Miss Pete's purported comments about his sexuality were discriminatory or harassing. In June 2023, Miss Pete called Mr. Garcia regarding insulting text messages about her that Mr. Garcia and Alejandra wrote and discovered. Mr. Garcia was blindsided and shocked by the call, but apologetic and made it clear Miss Pete's points were valid. On the call, they discussed Mr. Garcia's issues with the lack of work he had with Miss Pete while she was on a break. They did not discuss any complaints regarding his wages. Mr. Garcia confirmed that he did not discuss the alleged discriminatory comment with Miss Pete on the phone call. After the 2023 phone call, June that is, Rock Nation understood that Miss Pete and Plaintiff had a falling out and she did not want to use him as a photographer moving forward. Okay? So this is a friendship gone bad, and he's trying to sue for it. Because they fell out, she didn't want to work with him no more, and now he's trying to get some money. That's what we thought the whole time, but this is what this is outlining. Mr. Garcia attended a strip club with Miss Pete in California one time. Miss Pete confirmed blank. Again, this is redacted. Why? I don't know. Other instances alleged in the SAC. Plaintiff does not recall telling anyone at Rock Nation that he believed Plaintiff restricted him from eating in her presence. But you claim that she wouldn't allow it. Plaintiff admits that he did not think anyone at Rock Nation created a hostile work environment for him. All right. So it does seem that something did happen in an SUV in Ibiza. All right. I don't know what. It was blinked out. But he never had an issue with it. And since they've fallen out, he's now using that situation as a harassment claim to try to get some money. He's also trying to use her association with Rock Nation as her management company as a way to get workplace wages that he never was actually due to receive. Scoring friendship gone bad. That's what this is. And after Megan discovered that he was talking bad about her, she cut him off. Sounds pretty normal to me. Now, how Emilio and his legal team are going to respond to this, I don't know. We'll have to see how the judge is going to respond to this, because Megan and Rock Nation are requesting a summary judgment that would get this, closed out without need for a trial. We don't know how that's going to work either, right? We don't know if the judge is going to grant it. We don't know if the judge might grant a partial summary judgment, or if the judge will all out decline and deny it and say, no, we need a full trial. As of now, that's what's on. That's what's on file. We're just gonna have to see how it play out, man. But it seems like much ado about nothing, and this was his get back to try to get some extra funds because work slowed up after she cut him off. That's all I got. But let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I will catch y'all on the next one. Y'all be good out there, man. Peace.
Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'll never politic and the drama be piling on. Father and greats unacknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5-6 bank accounts, every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I'll turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I read for filth. The sympathy cause consulting for the stacks I built. I had to